If you got into a car accident tomorrow and couldn't make decisions for your kids, do you know who would? Most Florida parents think their family will automatically step in and handle everything, but that's not how the law works. In this video, I'll show you exactly what happens to your children if you're incapacitated in Florida, and more importantly, the simple legal steps you can take right now to make sure they're protected. Hi, I'm Stephanie Padley-Julian, founder of Padley Law. As a mom myself, I understand how important it is to protect your children, your home, and your legacy. For over 15 years, I've helped families across Florida create personalized estate plans that give them the peace of mind they deserve, knowing their loved ones are cared for no matter what. If you're ready to protect your family's future, I'm here to help. Call us today at 239-963-6043. First, let me clarify what incapacity actually means, because this isn't just about worst case scenarios. Incapacity means you're unable to make legal, medical, or financial decisions for yourself. This can be temporary, like after a car accident, during a surgery complication, or while you're in a coma. Or it can be permanent, like after a stroke, traumatic brain injury, or a dementia. And here's the thing most people don't realize. This doesn't just happen to elderly people. Accidents and sudden illness can strike anyone at any age. I've worked with families where a parent in their 30s or 40s became incapacitated unexpectedly. In those situations, without the right legal documents, everything comes to a halt. Bank accounts get frozen, family members can't make medical decisions, and worst of all, no one has legal authority to care for the children. These families end up spending thousands of dollars and months in court, all during one of the most stressful times of their lives. So what actually happens to your kids if you don't have the right documents in place? Let me walk you through the three main problems that Florida families face. The first problem is that no one can make medical decisions for your children. Without proper medical authorization documents, doctors legally cannot consent for treatment, not even from grandparents or family members you trust. In emergency situations, this creates delays that could be dangerous for your kids. A child may need surgery, but because the legal guardian wasn't named in the right documents, the hospital had to wait for a court order before they could proceed. That's time your child doesn't have in a real emergency. The second problem is that no one can have access to money to care for your kids. Your bank accounts get frozen without a power of attorney. That means family members can't pay for childcare, school expenses, or even basic needs like groceries and clothing. They have to petition the court for guardianship, which takes weeks or sometimes months. During that time, your kids could be placed in temporary state care while the courts figure everything out. I know that sounds extreme, but it happens more often than you'd think. And the third problem is that the courts decide who takes your kids, not you. If both parents are incapacitated and you don't have legal documents naming guardian, Florida courts will appoint a temporary guardian for your children. This may not be the person you would have chosen. And when there's a disagreement among family members about who should take the kids, those fights happen in court, which is traumatizing for everyone involved, especially your children. Now, there's the good news. There are specific legal documents that solve all three of these problems, and they're simpler than most parents think. The first document you need is a medical authorization for minors. This document legally authorizes someone you trust to make medical decisions for your kids if you can't. You can name a short-term guardian for temporary situations and long-term guardians for permanent incapacity. This is specific to each child and gives the person you choose the legal authority to act immediately. Think of it like giving someone your house key while you're away, except this key unlocks the ability to care for your kids when you can't. The second document is a durable power of attorney. This allows someone you trust to access your finances and make decisions on your behalf. The word durable means it stays in effect even if you're incapacitated, which is the whole point. This protects your kids from bank account freezes and court delays. One important thing to know: in Florida, this document needs to be properly witnessed and notarized, or it won't hold up in court. The third document is a designation of preemie guardian for minor children. This legally names who will take care of your kids long term if you can't. It prevents court battles between family members and allows you to include instructions about your values, how you want your kids raised, and their education, and even their religious upbringing. And here's something most parents don't know. This is not the same thing as naming guardians in your will. It will only takes effect after you die, not if you're incapacitated. That's why you need this separate document. Now, I know what some of you might be thinking. You're young, you're healthy, you'll get to this later, but let me tell you why that's the riskiest decision you can make. Incapacity doesn't discriminate by age. The younger your kids are, the more urgent this becomes because they need someone who can legally care for them immediately. Some parents worry that setting this up is too expensive, but here's the reality. If you don't have these documents and you become incapacitated, your family will spend thousands of dollars or more in court costs just to get emergency guardianship. These documents cost a fraction of that. And if you're feeling overwhelmed by all of this, I want you to know that the right attorney makes this process simple. If you're a Florida parent who wants to make sure your kids are protected, no matter what happens, call us today at 239-963-6043 for a 15-minute consultation. We'll walk you through exactly what you need and answer all of your questions. Now, here's something most Florida parents don't realize. Even with these documents in place, if you don't handle your estate plan correctly, your family could still end up stuck in probate court for months or even years after you're gone. In my next video, I'll show you exactly how to avoid probate in court with the right estate plan. Click here to watch it now.